My lady, with your ladyship's leave, I propose to make my submission under 3 headings. First, before dealing with the submissions of Mr. Hart, I propose to spend 45 minutes or so picking up some points about the context in which the 1991 legislation was passed and then the 99 legislation itself. Then I propose to deal with the proviso issue. And then
I'm sorry to interrupt, but I seem to have no sound.
Oh dear.
Not quite sure why that is.
I'm not sure whether that's a
Well,
benefit or not.
It's not helpful for me to say, oh, we can hear you, because you can't hear me saying that.
Does it look as though everything's green here?
It's probably not you, Mr. Karras, it's probably the system.
Yes, and I think somebody's doing what they can.
It's not apparent to me why I have no sound. So what I'm going to do is I'm going to leave and rejoin and see if that solves the problem.
All I can do is wave.
It might be the first occasion in which council makes its submissions through the medium of mime.
Well, I think we'll have to adjourn for you to, it wouldn't be truly mine, but nevertheless to get yourself some props. You need some pipes.
Oh, yes.
I have to say that I thought we were so fortunate yesterday that everything went without a hitch, so it's all come back to bite us.
Hello? If you can hear me, someone is going to come to sort it out, the volume, because apparently we cannot hear you. So Alan will be there in 2 minutes, max. Thank you.
I think perhaps we should rise and try again in a few moments. Thank you.
Testing.
Right. So I don't know if I have sound or not now.
Testing. No.
I heard something just there.
My lord, can you hear me if I stand here?
Yes, very clearly.
Thank you. I'll let the your colleague.
Shall I try as well? Can your lordship hear me now?
Yes, I can. Yes, I can. Thank you.
Splendid.
Yes, that's all much better now. Thank you.
Thank you.
Lord Justice Arnold, can you hear us?
Yes, I can this time, thank you. It's a lot different from last time where I couldn't hear a thing.
Thank you very much, and we can hear you. I wonder whether, although I don't want to ruin anything, whether it's possible, please, to try to get rid of the number pad on the right-hand side. Is that possible? Thank you. We've got a large number pad on the right-hand side of our screen so that when we look at you, we haven't got the full glory.
Okay.
But that can be dealt with as we go along. I'm sorry to have kept you, Mr. Carris.
No, not at all, my lady. As I was saying, I propose to make my submissions under 3 headings. First, before dealing directly with the submissions of Mr. Hart, I propose to spend 45 minutes or so picking up some points about the context of the 1991 legislation and the 1991 legislation itself. Then I propose to deal with the proviso. Then I propose to deal with Mr. Morgan's submissions about the effect of the agreements. Before I do that, it might assist for me to summarise what I say on each of the appeals somewhat more succinctly than I have done in the somewhat lengthy skeleton arguments. Because we submit that the answer to both appeals can be expressed very simply. On the 2018 appeal, we say that the case is on all fours with, or at the very least directly analogous with, Marchich. The provisos, while limiting statutory authorisation, say nothing about the consequences of a discharge in breach of that limitation. So in order to establish whether a claim exists, the Marchich question, which we'll come to in due course, needs to be asked, and we say the answer is that where a claim in substance is that existing sewers lack sufficient capacity and the remedy is that more sewers must be built, this is a matter for the regulator and not the court. That is our case. Then on the licenses point, we say each agreement contains an unqualified obligation on the local authority to stop up a sewer within a specified time. And we say on the true construction of the statutes in force at the time the agreements were entered, local authorities had no power to bind themselves in such a way. We also, as your ladyship has seen, have an alternative argument which we raise in our respondent's notice, which the judge at first instance considered he didn't need to decide. And we say that in any event there would be an incoherence if a landowner could render unlawful discharges of sewage which prior to privatisation were authorised within the scope of a local authority's powers simply by terminating an agreement in circumstances where the statute itself precludes the stopping up of a sewer. So that, in essence, is what we say, and as I indicated, our skeleton arguments say it at greater length, but that is the bare bones of where we're going. So if I can come to context, again, I propose to deal with context under 3 more headings. The first, I propose to look at the statutory position prior to privatisation. This is relevant, we say, to the understanding the nature of what sewerage authorities, as they then were, could do, and what the sewerage undertakers under the privatisation regime inherited. And this is directly in play on the licenses point. It's also relevant to understanding what was decided in the pre-privatisation cases, which have been described as a rich jurisprudence. Secondly, I'll look at the mischiefs at which the privatisation regime was directed. and then finally I'll pick up some points in the legislation itself. So dealing first with the legal framework governing sewers prior to privatisation, as your ladyship has seen from Mr. Hart's submissions and in the pre-reading, the modern law of sewers really started in 1875. Before that, to deal with sewerage, it was left to local authorities to promote local acts.
I thought Henry VIII set up commissions of sewers in the 16th century.
He did, but immediately prior to that, under the 1848 legislation, it was up to the local authorities to invoke the powers of that act, and following a commission of an inquiry, an order in council would be promulgated, and under that regime, it was left to local authorities whether or not to promote sewerage infrastructure within their area. And significantly, there was no general public right to connect to sewers constructed by local authorities under that legislation. The 1875 Act changed that, and I propose to look briefly at its structure. Your Lordship has seen it already, so I can take it fairly quickly. It appears in volume 1.1 of the authorities bundles at tab 3 on page 25. On page 26, one has definitions, including local authority. Now, 3/4 of the way down the page, and over the page on 27, there are definitions of drain and sewer, which are particularly illuminating, but that's where one finds them. Then, going forward in the bundle, part 3 of the Act starts at page 29, and one sees the general provision for the vesting of all existing and future sewers within a district. And this is an important provision because effectively overnight, rather like the modern regime on privatisation, overnight local authorities had vested in them existing infrastructure, though there were a number of exceptions. Many sewers have been promoted by local authorities under local legislation, but the important point is, as a generality, sewers vested in local authorities overnight. On page 30, my learned friend Mr. Morgan referred to section 14, which hasn't figured in any of the arguments to date. We'll come back to that when dealing with Mr. Morgan's submissions. We will respectfully submit that in essence, this provision deals with the acquisition of extant rights, but in any event, it's subject to the proviso in section 17, and in any event, it will make no difference to the way we put our case on the license point, but the license point, which I'll come to in due course. Then Mr. Hart has already taken you to section 15, duty to repair and maintain, section 16, the power of making sewers, and then the proviso, which indicates that nothing in this act shall authorise any local authority to make or use any sewer, drain, or outfall for the purposes of conveying sewage or filthy water, etc. So this is
Sorry, you skipped over section 15 quite quickly. You described it as a duty to repair and maintain, which it does contain, but it also contains a much more important duty, which is to cause to be made such sewers as may be necessary.
Your Lordship is quite right.
Clearly, the 1875 legislature envisaged that sanitary authorities would build sewers whenever necessary.
Quite so. That's the
parliamentary expectation, which has been regularly disappointed for the last 150 years.
Indeed so. As populations increase, it's very difficult to keep up with the requirements of the population and indeed climate.
This is now what's now Section 94.
Well, part of Section 94.
The effectual drainage bit.
Yes.
And is it correct that your client and all other sewerage undertakers have been in breach of Section 94 since the day they were set up?
To a greater or lesser extent, one makes no concessions about any particular case. I
think it's your case. You are necessarily in breach of that duty from day one. And
indeed, in relation to the infrastructure we inherited, it's impossible. It would be impossible to comply with it overnight.
But I think your case is it's not only impossible to comply with it overnight, but since you've been in place now, since 1991, it's been impossible ever since because you would need to spend unlimited amounts of money to actually do it.
That is indeed the evidence.
I mean, it is, as I say, it is a fact that this is obviously what Parliament expected in 1875 and has expected ever since, and it's never ever been complied with as far as
that is entirely fair. And indeed, as one sees in the 1936 legislation, there's the additional provision about the effectual dealing with the contents of sewers comes in, and that's perhaps more in play when one's looking at the proviso issue. But yes, originally local authorities and now sewerage undertakers have been put in impossible positions because in 1875 the local authorities inherited infrastructure overnight, and it was simply not possible for them to comply with this duty. As one sees, that it was constantly litigated, has been constantly litigated up until every iteration of the legislation.
Thank you.
Could I just make a small request? Mr. Karras is crystal clear to me. Lady Justice Asplin is also pretty clear to me. But Lord Justice Nugee, for some reason, is quite muffled to my perception. I'm not quite sure why that is so. But if there's anything that could be done to improve Lord Justice Nugee's audibility, I would appreciate it.
Or I could just stop saying anything.
That was better. Thank you.
I feel possibly that I ought to lend him one of the 3 microphones that are in front of me, but I hesitate to touch anything, so we'll see what happens.
Now, I'm grateful to my Lord Justice Nugee for picking me up on that. It was obviously something we were going to come back to in more detail when we looked at the Section 94 duty, but we've dealt with the point extensively now, and it is a point which, as my Lord Justice Nugee has pointed out, underpins part of our case. I was on Section 17, and was drawing attention to the words which indicate that this is a constraint upon powers of the local authority, which is important for a point I'll come to in a moment. The relationship has seen over the page Section 18 already, the alteration and discontinuance of sewers, and I won't reread that. We'll come back to that in due course. But then on the same page, after Section 19, the duty to cleanse, and the duty in Section 20 to keep a map of the system of sewerage, one sees what's described as the power of owners and occupiers within a district to drain into sewers of local authorities. I won't read it out.
And so this is the power to connect.
The power to connect, or indeed it's a right to connect, and as we'll see from the case law, it's an absolute right to connect. And the important point is this is a right of owner or occupier of any premises to connect, and it's not qualified by the proviso, which of course deals with which of course limits the authorisation of local authorities. So this right is not qualified by the proviso. And then going forward on page 34, your ladyship's already been taken to section 299, where local authorities are in default. There's a complaints procedure by the local government board. Page 35, there's provision for compensation in the case of damage under section 308. Then on page 37, we have section 327, which are protective provisions. Consent is required. Then under subsection 6 and section 332 on page 39, which is in play, consent is required if there's injurious affection to water.
And in relation to 327, I think the issue arose about whether the appellants were a dock authority.
We haven't. I think we may have researched it in the past. I don't have the answer to hand. We say it doesn't make a difference to our case. It is something we will have looked at sometime in the past, but it's never featured in the arguments. Then on page 40, one sees the 1936 Act. The essential features of the 1875 Act were retained. There are two matters to which I draw the court's attention. The first is on page 41, and this is now an extension of the general duty of the local authority, which I discussed with my Lord Justice Nugee just now. The duty is extended to providing for the effectual dealing with the contents of sewers. And the second point about the context is that there is no longer a provision for automatic vesting of a sewer when it's created. The need for this seems to have arisen because there was a raft of litigation after the 1875 Act where people built defective sewerage systems and sought to foist them on local authorities. Instead, there was a provision for adoption by local authorities, and that's found in sections 17 and 18. And there's an express power to agree, enter into agreements relating to discharges, and this is a point we'll come back to in due course.
It's a bit like adopting a road as a highway.
A bit like adopting a road as a highway, yes. But there's no, it's not all automatic. There's a discretion. I'm not sure whether we've yet handed up a ready reckoner of a table showing coincidence between the 1875 Act and the 1936 Act. If relationship, if you have, then that I needn't take the court's time any further on that. I've drawn attention to the main 2 points. I will now go briefly to the 1973 Act, which I don't think Mr. Hart dealt with in much detail. There are some features of that legislation which are relevant to the background. The 1873 Act starts at page 62 of
1973 Act.
the 1973 Act. I'm so sorry. The 1973 Act starts at page 62 of the bundle. One sees now for the first time in subsection 1, subsection 2, we have a national policy for water. Clearly it is considered that the issues facing infrastructure needed to be dealt with in a coordinated way, and it appears that this was enacted following our accession to the European Economic Community, as it then was, under which we undertook certain environmental obligations by treaty. But that's a matter of background. But the important point to note is we now have a national policy for water and policy in relation to coordination becomes an important feature of the legislation. One sees at section 2, as Mr. Hart pointed out, water authorities replaced local authorities as the responsible bodies, and these were provided on a regional basis. We also see at section 4 on page 65 the establishment of a national water council whose functions relate to policy. One sees that in particular at subsection 5, 5A, their duties to consider and advise any minister on any matter relating to national policy for water and so forth.
Was each water authority responsible for the supply of water and for sewerage?
Yes, as local authorities were previously, and as now the statutory undertakers under the 1991 legislation are the.
So your client is both a water supplier and a sewerage undertaker.
Yes. I think that's the case in relation to all the appointed undertakers under the 1991 legislation. They become successors to the regional water authorities.
John, that's true that everybody who's a sewerage undertaker is also a water undertaker, but there are several who are only water undertakers.
I'm told that there are some vestigial water undertakers, but the general position is that those who are sewerage undertakers are also water undertakers.
Yep.
My Lord, in essence, the provisions again were replicated across from the 1936 Act. The new feature that was introduced as far as customers were concerned, members of the public as they were in those days, I think it's only after privatisation they became customers. One turns to page 71 and sees section 60, which made provision for the requisition of sewers subject to payment of a financial charge. So that's the main features of the pre-privatisation legislation.
Does this goes beyond the right to connect?
Yes.
This is, I'm building some buildings. I want you to provide a public sewer.
Exactly. One has a right to connect an existing sewer, but now one can requisition the building of a new sewer, though that is subject to financial charge. that carries across into the privatisation regime, as we'll see.
Yes, I see.
Now, if I can come to the second point, which I said I look at, that's the mischief at which privatisation was in part seeking to remedy. Before I do that, it might be relevant at this stage to note one point that Mr. Hart made about the context of Section 117, the proviso. He suggested that there's nothing in the privatisation regime had changed. And we were looking in more detail at the nitty-gritty of what actually changed in terms of statutory wording and the application of Section 117 in due course. There are two important points of more general context. First, as Mr. Hart pointed out to you, though not in relation to this point, in 1989, and we'll come to it, there was an entirely new enforcement regime. And secondly, this is the point I'm coming to now, the privatisation regime was concerned at remedying a number of mischiefs. And that is an important part of the background against which one must construe each part of the 1991 Act.
When you say the privatisation regime, you mean the 1989 Act?
The 1989 Act, and then the 1991 Act. Because the 1991 Act, although described as a consolidation act, as your lordship has seen, in fact caused substantive changes, not least in relation to the entitlement to discharge from sewers laid under the pipe-laying power. Now, instead of having the automatic right to discharge, which one had previously because the provisos applied to the pipe-laying power, now in the absence of the application of the pipe-laying power to the provisos, we have to use powers of compulsory purchase to acquire rights of discharge. From
that's what the Supreme Court decided in this case in 2014.
Well, it's what the Court of Appeal decided in the British Waterways case, which was confirmed in the Supreme Court in this case. My argument that British Waterways was wrong was rejected, but we had the other argument which was accepted, that pre-privatisation sewers retained rights of discharge and weren't to be stopped up overnight.
There was some suggestion that might have been a legislative oversight, just a quirk of the way the legislation had been drafted. Is that something we need to?
Well,
with?
I'm not sure how one can get there, because both the previous Court of Appeal and the Supreme Court have assumed that this is how the legislation falls to be considered. And we're bound by the Supreme Court, and indeed this court probably would be bound by the decision on the narrow ratio of British Waterways Board. However much I'd like to argue to the contrary. The background to privatisation has been set out in Marchage, to which we'll come, and your lordship probably has a fair idea from pre-reading what's there. But I do propose to look at the evidence to which we've referred in the skeleton very briefly about the context and the extent of the problem and what the privatisation legislation in 1989 was intended to address. We summarise it first of all in paragraphs 10, 53 and 54 of our skeleton argument, and just remind your Lordship what we say there. Volume 1 of the core bundle, tab 4, page 51. So we refer to the white paper, and we refer to the background in more detail of paragraphs 53 to 54. The court also has before it a witness statement of Keith Hendry, which is in the supplemental bundle. If you put the core bundle away, Mr. Hendry's statement appears tab 13. Mr. Hendry being an aquatic scientist with considerable experience of the Manchester Ship Canal. Paragraphs 6 to 8, which I draw attention, he refers to the state of British sewers as they existed in the 1970s and early 1980s. And he refers to a letter of Michael Heseltine, as he then was, which is a tab 14.
Is he not still Michael Heseltine?
I think he might now have more titles.
More titles, yes. Or just to look at it?
My lord, yes, it's page 278. One sees the trenchant terms in which he describes the Mersey in paragraph 4. But today the river is an affront to the standards of civilised society, should demand of its environment. Untreated sewage, pollutants, noxious discharge, all contribute to water conditions and environmental standards, but are perhaps the single most deplorable feature of this critical part of England. This is obviously relating to a regional problem, but it is part of the background which the Secretary, against which the legislation should be viewed, in my respectful submissions, as an official document of the Secretary of State.
It describes matters in rather florid terms, but you do have, in any event, paragraph 8 of Mr. Hendry's witness statement,
yes,
where he describes the canal in the 1980s.
Yes, quite so.
Yep.
Then we have the white paper, which is summarised in the evidence of Mr. Hazlitt. I don't propose to turn it up because I'm going to take you to the material passages. But in the evidence, it's in supplemental bundle tab 5 at page 113. But the white paper itself appears in volume 3 of the authorities bundle, which is the slim bundle. It's tab 70 at page 24. We can take the court to page 27, paragraphs 2 and 3. One sees the white paper set out the reasons for the decision and the basis of the legislation which the government intends to put to Parliament as soon as possible. And one sees a number of bullet points. It's probably quickest if the court reads it to itself, but I draw particular attention to the third bullet point, where one of the reasons was to allow for access to private capital markets, which would make it easier for authorities to pursue effective investment strategies for cutting costs and improving standards of service.
Where does this take us, Mr. Karras, when you accept that actually the position is that sewage systems do not cope with the demand upon them, and therefore that there is a general breach of Section 94? This was perhaps wishful thinking.
Well, it goes to this. The scheme of the Act, which we'll look in more detail, was designed to provide a mechanism for securing
that greater
funding.
Investment.
And that is important. And then, as your ladyship pointed out, when one's looking at Section 2 of the 1991 Act, there are then duties on the Secretary of State to balance various factors in making decisions, which then feed in to the enforcement regime and indeed how the attempts by local authorities or by sewerage undertakers to comply with that Section 94 duty are to be achieved.
Yes, you say that. So this is the precursor to the entirety of that
Exactly.
regime, that structure.
Exactly, and this is what it comes to. And rather than take a lot of time looking through it, if I can just flag up the particular paragraphs to which we would refer. One sees at paragraph 5 that the interests of customers are being regarded as benefited by the new privatised regime, or will be in due course. One
And
sees
the
that at
environment.
6. And indeed,
Mr. Carrot, could I put my lady's question a different way? What you're reading to us is a statement of the political objectives and philosophies underlying the legislation. Now, clearly, those were the political objectives and philosophies, but so what? We have to construe the words of the legislation as enacted by Parliament.
well, yes, indeed. But from this, one can see two things. First, one sees the nature of the problem. Where do we secure?
Well, the nature of the problem was thought to be public ownership, and the answer was thought to be private ownership, and that's what Parliament then enacted. But where does that get us?
Well, where that gets us is that prior to privatisation, there was perceived to be a need to secure investment from privatisation, and there was seen to be a need to provide benefits as a result. It doesn't take us very much further than that, which one can infer, we say, from the statute. But it is, we submit, a relevant consideration when one comes to consider these statutes, to identify the mischief. And the mischief, as one can see, there was a problem with infrastructure, and we see that from the letter of Michael Heseltine, and it may follow as night as follows day that there was a need for investment, but one can infer from this that Parliament was concerned with securing investment. And that's really why we look at that. And the interests of the investors are something which we'll see are taken express account in the Act. And we say that feeds in to how the balancing exercise is to be interpreted. I'm not intending to take a great deal of time on this, but we say the white paper helps illustrate the mischief at which privatisation was aimed. It's not simply privatisation for privatisation's sake. It's privatisation against a background of there being a pressing environmental need and a need for investment to cure the problem. So that's the mischief which I say can be derived from the background. This isn't simply, as I said, a case of privatisation for privatisation's sake. Privatisation to cure a specific problem. Whether or not it's worked is another matter. And that's what I derive, or seek to derive, from looking at this, albeit briefly.
Does it come to this, that when it's in public ownership, if the sewerage system's going to spend capital money, that has to be public money?
Yes.
And is subject to treasury constraints. When it's in private ownership, it can raise capital on private markets, but that's subject to other constraints because the legislation requires a reasonable return on capital to be provided and consumers to be protected against excessive charges. So there are also constraints on expenditure in the private system, but they're different constraints.
Yes,
Is that what it comes to?
That's what it comes to. How it's worked out in practice. But one sees that as I said, the mischief is a simple one. That's all I'm seeking to illustrate from this. That it was in the minds of Parliament, because this is the mischief identified, that there was a need for capital investment to provide environmental benefits for customers and for the environment, and the way of achieving that was through privatisation.
Can I ask a simpler question? On page 30, there's a map, which is much more accessible. Those were the 10 regional water authorities at the time?
They were, yes.
Are they effectively what the 10 sewerage undertakers now are?
Yes.
You've taken over the Northwest.
We've taken over the Northwest, yes.
Thank you.
Yeah, and perhaps I can just come on to another feature which one sees. I won't take you in detail to the provisions. Originally, in the original white paper, it was envisaged that the new sewerage undertakers would effectively look after the environmental impact as well. This was considered, for obvious reasons, to lead to a conflict of interest, and indeed the pre-privatisation regime that there was a conflict of interest because effectively the state was marking its own homework. But now, following the original white paper, there was a subsequent white paper which, again, I won't take the course to, but it's at page 55 of tab 71 of this bundle, in which there was a commitment to setting up the National Rivers Authority, which then became the Environment Agency, and that was to have certain policy objectives, which are set out on page 72 of the bundle. But one sees that more clearly when one looks at how the environmental legislation was enacted. Paragraph 4.6 sets out the policy objectives of the Secretary of State. So I take my Lord Justice Arnold's point entirely. We have to construe the statute itself, but I do derive the point that this is not simply a case of privatisation for privatisation's sake. It was designed to, for better or worse, whether or not it succeeded, remedy a particular perceived need. And that brings us to the Water Act 1989. I needn't take your ladyship to the provisions. The effect was summarised in the Supreme Court's judgment in the 2014 decision at paragraphs 7 to 8. It's in Authorities Bundle 2.5, tab 63 at page 88.
I'm sorry, could you repeat
That's-
that? Which volume?
2.5 of the Authorities Bundle.
Thank you.
This is MSC.
Yeah, exactly. The earlier iteration of the litigation between Ship Canal and United Utilities. The relevant. I'm sorry, I've got the wrong.
It's not 88.
It's not 88. If your lordship will bear with me.
Are we at
1133.
1128?
Which paragraph?
It's paragraphs 7 and 8.
1133.
I'm grateful to my learned friend and to my lady. But and significantly, as Mr. Hart pointed out, at this stage, the predecessor to Section 18 comes into force. But that's all I ask the court to note. But for present purposes, we'll come back in due course.
Do we know what the transfer date was? Was it the same for all the authorities?
It was the same for all the authorities, yes.
Do we know what it was?
It's the first of December, 1st of September 1989.
Thank you.
Yes, there was a transfer. There was the transfer date in which the undertakings were transferred to companies which had been set up by the state, which were then sold off. They didn't go into private ownership immediately. They went into companies which could then be privatised. Well, my lady, if your ladyship could take up the first bundle of authorities, the statutes, I now propose to look at what we say are the key provisions of the 1991 Act, which appears at tab 9 on page 138. No, I'm so sorry, at page 126.
Tab 12.
Oh, is it tab?
Yes.
As currently in force. 9 is as an act. Sorry,
No, it's the other way around.
other way around. 12.
Yes, if we could look
Water
at
Act 1989 is at 9.
Oh, so I'm so sorry. We're looking at the 1991 Act.
Exactly,
Yeah.
and the
That's tab
1991
12.
Act is at 12.
And 13 is as an act.
Yeah, I've got it on page 126. Unfortunately, I haven't been given tabs. So
That's tab 12.
It's tab
It is,
12.
and it's 126, absolutely.
Yes. The court's already seen that Section 1A establishes the body corporate the Water Services Regulation Authority, which replaced the Director. Section 2, Mr. Hart took the court to. We say this is one of the central provisions, if not the central provision of the legislation, because it's from this provision that one sees the various competing interests which need to be balanced. This imposes the duties on the Secretary of State and Ofwat. And one sees at 2A the various competing interests. They must exercise and perform the powers and duties in the manner which it considers is best calculated to further objectives A to E. And as your ladyship has seen, the consumer objective is further defined in section 2, capital B, at the bottom of page 127. Then over the page, to 2DA, one sees the resilience objective further defined. So we respectfully submit that one can see here that the Secretary of State and Ofwat are to take a long-term view in relation to sewerage systems. And jumping ahead to the submission we'll be making in due course, we say that allowing private litigants who have sufficient resources in any given case to litigate in relation to matters of the priorities to be set by the Secretary of State and Ofwat is on its face at the very least potentially inconsistent with securing this objective.
I'm not sure it much matters, but can you explain to me where in this list of 5 objectives one finds protecting consumers against excessive charges? Because it doesn't seem to fit within 2B. Well, as I understand it, one of the things that Ofwat does is to, in crude terms, put a cap on the charges that undertakers can impose. And it's not apparent to me why that's within 2B.
Well, 2B refers to the interests of consumers, and it must be in the interests of consumers that what they pay for provides value for money. So taking one of the points made in Mr. Hazlitt's evidence, some schemes for environmental improvement might provide only marginal environmental improvements compared with their costs. And that being the case, the Secretary of State or Ofwat could take the view that while there would be, it might secure an environmental objective, it would not be in the interests of consumers because they would be paying for something which would only have a marginal benefit to them. And that's how...
Yeah, all right. I'm a bit more interested in the statutory wording. So as I understand it, your submission is that we read subsection 2B as implicitly containing the word including after the comma in the second line. So what you say is what this means is to protect the interests of consumers, including but not limited, where appropriate, promoting effective competition between persons engaged in, etc.
And well, one also needs to go over to 2C in order to understand what the interests of consumers might be, because at 2C one sees that for the purposes of section 2A, which is the consumer objective, the authority, Secretary of State or the authorities, the case may be, shall have regard to, amongst other things, individuals with low incomes. So this is where we would say, the interests of...
Yes, I'm sorry, you're not getting my point. Okay. What I was wondering about was that one might perhaps have read this as saying that the way you protect the interests of consumers, including those on low incomes, is by fostering competition and thereby driving down prices. But as I understand it, you say, and this may well not be in dispute, that actually it's not limited to fostering competition and thereby driving down prices. It includes, in addition to fostering competition and driving down prices, capping charges.
Well, perhaps I can put it this way. The words, the interests of consumers, are ordinary English words. What might or might not be in the interests of consumers will depend upon the facts of any given case. In some cases, it may be driving down charges. In other cases, at other times, it might be in securing environmental improvements. But these are matters of judgment.
I don't think you're answering my Lord's question. My Lord's question is focused on what the language of subsection 2b means. Does it mean the consumer objective is to protect the interests of consumers by promoting competition? Or does it mean the consumer objective is to protect the interests of consumers, including where appropriate?
Oh, I'm so
by
sorry. I'm so
promoting
sorry.
competition? I think that.
Well, the point is, I'm sorry. I'm being obtuse. I apologise. The point is, it says wherever appropriate, by promoting effective competition between persons engaged in, etc.
So it's not limited.
It's not limited because we have the word appropriate. I'm sorry. I was missing your lordship's point and being obtuse.
So wherever appropriate, in effect, is the same as, or maybe as having including.
As having including. A decision has to be taken on whether it's appropriate. That's the way I put it. One doesn't need to read in the words including. One doesn't need to imply anything. What one needs to do is consider the factual, or the regulator and the Secretary of State need to consider the factual question: is it appropriate?
And so your submission is, in relation to 2 capital B, that the consumer objective is to protect the interests of consumers, full stop, in effect, or stop there, and therefore, but wherever appropriate, that might be by effective competition.
Yes.
Thank you.
Milady, I very much apologise for rising.
No, I'm sorry. I noticed you had done before. I'm sorry, Mr. Morgan.
I hope this will assist the court. Mr. Karras is referring to the Water Industry Act 1991 as currently in force. Matters, in my respectful submission, become much clearer if we look at the section 2, as enacted, which you will find in the same bundle at page 294. I'm sorry, I'm told it's the second volume.
It's the next volume.
Next volume at page 294. Amongst other things, the court will see that expressly addresses charges. And well, it's section 2 is in a very different form. As originally enacted, section 2, subsection 3 addresses the point.
But it is a bit odd, because as you point out, as originally enacted,
Yes.
Section 2, subsection 3 expressly said that the duty is to ensure the interests of customers, as they were then called, are protected as respects the fixing of charges. And that language has disappeared in 2003, and there's no obvious reason why it's disappeared.
Yes, I can see your lordship's point, but we say the wording on its face
Is wide enough.
Is wide enough, picking up the question asked of me, which I obtusely failed to understand, of Lord Justice Arnold, because we have the word appropriate. It doesn't say promote the interests of consumers by promoting effective competition. It just says wherever appropriate. So we don't need an implication of my respectful submission. And of course, one needs to bear in mind that one is dealing with what are, in effect, monopolies. So, in the context of there being a monopoly, one can see how some effective price capping becomes something which would, on the natural meaning of the word, promote effective competition. Rather, not effective competition, promote the interests of consumers, because it's not promoting effective competition, because you can't promote effective competition where in practice there is a monopoly. This must go wider than simply that.
Okay, Mr. Harris, we've got a bit bogged down in section 2.
No, it's an important. We say it's an important section. So just summarising where we get to from section 2, it's plain we respectfully submit that it is possible, indeed there is obvious potential for the various competing interests identified to conflict. The financial interests of consumers, customers, and the interests of the environment against the interests of investors and the interests of, and so forth. They may each conflict, and how that conflict is to be resolved is inevitably a matter of balance and judgment.
Well, that's in the very words of 2A. The authority shall exercise and perform the powers and duties mentioned in the manner which is considered to be is best calculated to deal with those that basket of things which may be quite inconsistent with another. So it needs balance.
It needs balance, and of course the important thing is in the manner which he or it considers is best calculated. So we're dealing with an exercise of judgment for the Secretary of State and the authority, and those words, I respectfully submit, are important. This is a matter to which the Secretary of State and authority are themselves to judge. If we can jump just before we leave section 2, we also have section 2, subsection 4 on page 129, which refers also to a requirement for the Secretary of State and the authority to have regard to the principles of best regulatory practice, including the principles under which regulatory activities should be transparent, accountable, proportionate, consistent and targeted only at cases in which action is needed.
Can I ask you something else before we leave section 2? What is a reasonable return on capital?
That's not being an economist, I'm not sure I can answer that question in economic terms, but it must be well, I said it must be. It's going to be a matter of judgment in any given circumstances, but it must
Does
be.
Ofwat specify what percentage return it regards as reasonable?
Yeah, it does, and I'll dig up the reference. But you've seen from the pre-reading that there's an AMP period, the AMP period, and as part of that process, in any AMP period, there is a decision on the rate of return which is appropriate in the circumstances to secure the investment. And I'll dig out the requirement, but it's not what I say is it's not in the statute as one would expect. It's a matter for the regulator to judge. If I can then, I think Mr. Hart has taken you to other provisions. If I can remind the court of section 11 on page 136. Which deals with the conditions to be attached to appointments. And when attaching conditions to appointments, it's the duty of the Secretary of State, or as the case may be, the Director of what, having regard to the duties imposed on him by Part 1 of the Act, and they're the Section 2 duties. And for your Ladyship's note, we have an example of an appointment in the supplemental bundle at tab 7. Might be useful just to dig it out. Page 202. And one sees, I needn't attain the court with the details.
Can't be an appointment under section 11.
I'm so sorry. Is it? Well,
1989.
sorry, it's not on. It's under. Sorry, this is on. Well, in fact, if one looks at the bottom at 202, although it's dated Department of the Environment, August 1989, it is in, when the original appointment occurred. This is, as one sees, if one goes to 203, these are amended. One sees from the colours. This is the August 2014 appointment.
Yeah, and we're told that consolidated working appointments are not formal documents and should not be relied on.
Well, the only purpose, the reason that I'm referring the court to this is to provide, to take the court to section 203, so the court can see how in practice from the table of contents on page 203, the scope of conditions which are as a matter of course imposed, including the regulation of charges, and these conditions see charges, schemes. It's there. It's in the evidence. I don't attach weight to it, save for the purpose of showing the court how this works out in practice. I've been asked questions on charges, so it's probably appropriate that I take the court at this stage to the charging provisions, and they appear going back to volume 1 of the authorities bundle at page 231. Section 142 gives private undertakers a power to fix charges for its services and demand and recover those charges from those to whom it provides services, then, and this may be an answer to my Lord Justice Arnold's question about capping. One goes to section 142, subsection 3A, on page 232, the power of the sewerage undertaker to charge for any services should be exercised only by or in accordance with the charge scheme under section 143 below. Section 143 sets out what may be included within the charging scheme, and if I can draw the court's attention to the provisions, first of all, of subsection 3A on page 234. Sewerage undertaker is under a duty to ensure that any charges scheme made by the undertaker, so far as having affected the recovery of undertaker's costs of providing a sewer, causes those costs to be borne by the undertaker's customers generally, and a sewerage undertaker's duty under this section shall be enforceable under section 18 by the Secretary of State. And then there are provisions in subsection 6, the authority to issue directions.
So 3A is if you put in a new sewer, you can't expect just the people on that new housing estate to pay.
Yes.
It's got to be evened out across.
One has to,
Yeah.
and it becomes enforceable under
18.
section 18.
Well, you can see from 6 that there are regulations and rules that may be made. We don't have.
We don't
know what
you
they
need,
are.
one needn't go there. So coming back to section 18, which I will spend a little time on, even though I'm perhaps taking it a bit more slowly than I was anticipating. Page 138. Subsection 1, the court has seen, and I needn't detain the court with it, the provisions which the court has read already. Effectively, there's provision made for enforcement orders. The battleground is over the meaning of section 18. 8, which the court has seen, the only remedies for causing or contributing to that contravention, apart from those available by virtue of this section, shall be those for which express provision is made by or under any enactment. We're not concerned with that. Those that are available in respect of that act or omission otherwise than by virtue of its constituting or causing or contributing to such a contravention. What this section doesn't do, however, is tell us what those remedies are. And we respectfully submit, in considering what those remedies are, one has to ask oneself the question posed in March, and we'll come to make that, I hope to be able to make good that assertion in due course.
So what do you say the effect of Section 18.8 is?
Well, so what it makes clear is that where there, so one asks the Marchage question, and in Marchage, despite Section 18.8, Mr. Marchage, despite the fact that there was an obvious breach of duty under Section 94, had no remedy. On the other hand, as one will see which we'll see when we look at Dobson, there will be cases when one asks the Marchage question, and there will be cases, for instance, in cases of negligence, where remedies do survive, and they are not affected.
Well, what I understand... Sorry.
It's the question, isn't it? I mean, you make the point about Marchage, and we understand that. But the question you were asked was what this subsection means.
Yes, and what we say is it preserves. What it means is that remedies are preserved. It tells us that. It does no more than that. But one needs to look elsewhere to answer the question of what those remedies are. So it only goes. So, in terms of meaning, it's only the first stage. It makes it clear that something is preserved, remedies are preserved, but the question is then what remedies? And one then, as one saw in Marchage, asks the question: are the common law remedies which would otherwise be available consistent with the statute? And if they're not, then they're not preserved. Then they're not preserved.
So as I understand it, you would accept, subject obviously to your overriding point on Marchage, you would accept that the natural meaning of the language used is that common law remedies are preserved.
If and to the extent that a common law remedy survives. So yes, indeed, in the case of Dobson, for instance, where in relation to some of the nuisances caused by the wastewater treatment works, the complaint was not that there was an insufficiency of infrastructure, but the infrastructure had been operated negligently. That common law remedy survived. So yes, answering your lordship's question more succinctly, the answer is yes, but subject to the qualification that one needs then to see what common law remedies actually do survive. This section does not answer that question.
So you say subsection 8 means that common law remedies are available as long as they are consistent with the regime, with the statutory regime.
Well, it doesn't talk in terms of common law remedies. One needs to consider yes, but that must be what it's primarily directed at. But as in Marchage, not all common law remedies will survive despite Section 18.8. That we say is decided by Marchage.
We will have to look at Marchage, because I think that the analysis of Lord Nichols and the analysis of Lord Hoffman are not entirely the same. I think Lord Hoffman said the complaint is a contravention of Section 94. That's not a tort, so you can't sue on it. And Lord Nichols said that Mr. Marchage would have been able to complain in tort were it not for the fact it was inconsistent. And we will have to look at that. But just looking at this, the primary purpose of Section 18.8 is to say you can't sue for the tort of breach of statutory duty.
Yes.
But it does clearly preserve something
Yes.
in the final words. The same act may be a contravention of Section 94 and may be something which would, at common law, be wrongful, either tortious or a breach of contract or wrongful in some other way.
Yes.
Prima facie, it preserves liability for those remedies. The remedies available are those that are available in respect of that act. I mean,
Quite so. But as I said, what it doesn't tell you is what those remedies are. and one needs to ask the Marchich question. Indeed, I'm repeating myself.
Well, I think we will have to look quite closely at Marchich, because on the face of it, one would have thought what this meant was, if what you're doing is not only a contravention of Section 94 but a trespass, then you can still sue for trespass. That's what it appears to say on its face.
It would do, or it might do, if one didn't go on to ask the Marchich question, because historically, very often, defences, as one sees from Pride of Derby, by local authorities sued in nuisance, was to say statutory authority. However, there's a different question which we say comes into play. Even if you're not authorised, as we're not authorised here, is a common law remedy consistent with the statute? And we say Section 18.8 begs the question. It simply refers to remedy, begs the question.
I think you do accept the way in which it was put by my Lady Justice Asplin a couple of minutes ago.
I may do, but I don't have the words quite in front of me. But in essence, well, perhaps the way I should.
Well, what she said was, what it means is common law remedies remain available so long as they're consistent with the statute.
I think that's what I'm saying. My lady has put it far more succinctly than I have, and I should have accepted the point and passed on quickly.
Thank you.
We then have Section 19, which provides exceptions to the duty to enforce. We say significantly in Section 19, subsection 1, subsection C, one of the questions is whether the duties which we've seen in subsection 2 preclude the making, or as the case may be, the confirmation of the order. So the balancing exercise, we say, has to be undertaken when considering whether or not enforcement takes place.
Do you also say that some of these supposed contraventions are of a trivial nature?
Well, in the present case, there's no admission as to the extent of any breaches in relation to any outfalls. They're entirely in issue. In some, they may well be.
But I think you do accept that the storm overflows and the other overflows do carry untreated sewage, together with rainfall, into the canal.
Yeah, as one sees from Mr. Hasnett's
Yes.
evidence, and in some instances, as you've seen, some might be regarded as trivial. In other cases, they won't. As you've seen, one talks about untreated sewage, but it is heavily diluted, so it is not in every single case going to be make a significant impact. And one has also seen his evidence that in relation to some improvements, there may be a law of diminishing returns. Some improvements, yes, they may improve the water quality, but it may be marginal compared with other breaches. So there may be instances in this particular case which would be trivial for the purposes of Section 19, but we haven't got there yet. We're looking at the matter as a matter of principle before we get to the factual issue. But there will undoubtedly be instances where that is what we say. Given the number of outfalls we have and the length of the canal. Section 22 makes provision for remedies in the event of non-compliance, and Mr. Hart took your ladyship to that, and one sees, this is at page 146, as Mr. Hart pointed out, that unless and until the Director or Rothwart makes an enforcement order, there's no remedy for breach of the statutory duty. There is, as we'll come to, the provision of section 95, but I'll come to that after we do with section 94, which is at page 161. And as my Lord Justice Nugee pointed out, there are two limbs. The second limb deriving from the 1936 Act being the duty effectively to deal with the contents of sewers, and the duty effectively deriving from the 1875 Act, the duty to provide, improve and extend the system of public sewers to ensure that the area is and continues to be effectively drained. And one saw, as Mr. Hart pointed out, subsection 3, the duty is enforceable under section 18. And section 94.4 makes clear that where other provisions create duties, they are separately enforceable. My Lord, section 95 was not something, or my lady, section 95 was not something to which Mr. Hart refers. Section 95, subsection 1, empowers the Secretary of State to make regulations to facilitate the extent to which breaches of the obligations which follow may amount to breaches of the general section 94 duty, and for the purposes of supplementing performance standards. Section 95.2 empowers the Secretary of State to make regulations that prescribe standards of performance in connection with the provision of sewerage services. And sewerage services are defined in section 219 on page 285. And we're concerned with A, in the case of a sewerage undertaker, includes the disposal of sewage and any services which are required to be provided by a sewerage undertaker for the purpose of carrying out its functions. So it's very, very wide. And then coming back to section 95 on page 162, it provides for regulations to provide for any person who's affected by a failure to meet such standards to be paid by the undertaker such amounts to be prescribed. Of course, as Court has seen in pre-reading Marchich, there weren't such regulations at the time, so poor Mr. Marchich didn't have a remedy, though there have been regulations introduced since. So somebody in Mr. Marchich's position can receive a relatively modest amount of compensation. But we'll come back to this, but the important point to note, I respectfully submit, that in deciding whether or not to make regulations and the extent of the remedy to be provided under those regulations, the Secretary of State will be bound by his Section 2 duties, which apply generally to him, so he will have to undertake a balancing exercise in deciding, firstly, whether to provide a remedy, and secondly, the extent of that remedy, given the burdens it will place on other stakeholders, to use the modern word.
Section 2 says by subsection 1 that it applies whenever he's exercising the powers by virtue of any of the relevant provisions. Do we know what the relevant provisions are?
I can maybe that I've made an error in this. Relevant provisions are I'm so sorry, they are, it looks as though they're on page 130. So one looks at subsection 6A2, that extends to section 95.
Thank you.
I think that's that makes good my submission. Now I can turn on to show the court, my lady, very quickly the bundle of powers and duties which sewerage undertakers currently have. The court has been taken to some of these, so I can take it very quickly. One starts at page 170. One sees the modern form of the duty to comply with a requisition under section 98. Going forward to page 182. Section 102, one sees the power of adoption. And there are powers in section 104 to agree to adopt at a future date, but we needn't look at those. There are also powers which I needn't turn up, which were referred to both in the British Waterways case and the Supreme Court in this case, the earlier version of this case. Under section 155, there are powers of compulsory purchase, and you've also seen reference to the pipe laying powers, and in section 158 and section 159.
Where do we find the modern iteration of the right to connect?
The right, this is what your Lordship has read my mind, because this is what I am coming to. Having looked at the powers, I come to the duties, and the right to connect is found in section 106, which is on page 200.
Thank you.
So there's a right to connect, and then thereafter to discharge the foul and surface water into the sewer. So it's not simply a right to connect, it's a right thereafter to discharge. There's case law on the absolute nature of this right, which we've included in the bundle. It's a house of it's the case of Barrett Homes Limited and Dŵr Cymru, which is in the authorities bundle tab 2.4, tab 56. If I can take the court just briefly to the main paragraphs on which we rely. This was at page 898 of tab 56. This was a case where the developer proposed to connect to a sewer in a location close to its development, which would have then led to overloading of the system. The question was whether the connection could be made where the developer wanted, or where the sewerage undertaker wished to determine at a place where the system wouldn't be overloaded. And it was held that the developer had a right to connect where it chose to do so. The main paragraphs to which I refer the court are page 906, first of all. Paragraphs 23 to 27, the court considers the history. I won't read those out. Then at the bottom of page 907, paragraph 31, the scheme of the legislation as reflected in the above proposition as affecting a developer can be summarised as follows. And one then sees on page 914, the paragraphs 55 through to 59, the conclusions on the point of connection. Paragraph 56 in particular, the lengthy history of the right to communicate with a public sewer does not suggest the point of connection has ever given difficulty in practice, and so forth. We can put that bundle away. Then, if we can then go back to the statute, the next section to which I want to turn is section 116 on page 227. And this is section which your ladyship has seen now more than once. In particular, one sees subsection 3, the requirements, the precondition there be provided a sewer that's equally effective. But I'm not sure my learned friend Mr. Hart took the court to subsection 4 in the current version, where it's provided that any dispute arising under subsection 3a, i.e. whether something is equally effective, is a matter to be referred to the director for determination. It's not a matter for the court.
Can I be sure I understand how you say this works in the case of not everyday sewers, but emergency sewers, overflows, storm overflows and the like? Because Mr. Morgan made a point that it's one thing to stop up a sewer which someone's using every day, and one to stop up a sewer that's only being used on occasional cases of heavy rainfall. So how does it work in a case? Take a combined storm outfall which carries both surface water and sewage. How does this section apply?
Well, it's a sewer. If it's a sewer, this section applies. Perhaps I can. We have included in the bundle some historic case law, which I think, which we did refer the judge at first instance to, and which is probably common ground between both parties about the nature of a sewer, and it might be helpful to your lordship to say what we say a sewer is, and even if a sewer is used in an intermittent manner, and even if actually it falls into desuetude, it remains a sewer. Though, of course, if it falls into desuetude, you may not need to provide something alternative to it. The propositions which I'll make, and then I'll refer your lordship to three cases very quickly, are these. A sewer is a conduit which carries off surface or waste water, and in order to carry off surface or waste water, it must have an outfall or at least some point of discharge. The second proposition on which we rely is that a pipe which, when constructed, cannot lawfully be used for the purpose of carrying off sewage, because its construction and use causes a trespass, for instance, as at the date of construction, is not a sewer at all. That's at the date when it's constructed. On the other hand, the third proposition on which we rely, provided a sewer serves the function of carrying off sewage, it is still a sewer, even if the discharge starts to cause pollution unlawfully. That becomes relevant when one considers the provisos. And finally, as with highways, once a sewer, always a sewer, even if physically stopped up. The test is, for what function was it constituted and does it exist? And I can make those points good very quickly, first by turning to the case of Meader, which is in volume 2.1 of the bundles. Probably sensible to put volume 1 away, and we'll come back to that because we'll look at the provisos. Tab 25 at page 72. This was a case where it was held that pipes which took away sewage were not sewers vesting in the local authorities. This is one of the cases which I indicated, one of the raft of cases where an inadequate infrastructure was sought to be foisted on a local authority. It was held that the pipes which took away sewage were not sewers vested in the local authority because they had never had a lawful outfall through which the sewage could be disposed of. In essence, the facts were these. Mr. Meader built 10 houses which drained into a cesspool. Then he took pipes over someone else's land to the foreshore, but had no license to drain. The pipes were then stopped up by the owner of the land crossed by the pipes. Mr. Meader argued that the local authority was responsible for dealing with the resulting pollution because the structure he built, he said, was a sewer and the cesspool was a thing belonging thereto. So they vested in the local authority under the vesting provision which we've seen in the Public Health Act 1875. And it was held by both Mr. Justice Chitty at first instance and the Court of Appeal that it was not a sewer because the works did not carry the sewage away. One sees, perhaps first, the first point, or the question being asked at page 79 of the bundle by Lord Justice Lindley. In argument, he asks the question, can a pipe which leads nowhere be a sewer? And the answer then effectively comes no. At pages 80 to 81, we've sidelined the judgment of Lord Coleridge. And we refer you to the blue sidelined paragraph at the bottom of page 80. On the part of the defendants, the argument comes to this, that really looked at sensibly in a common business point of view, this was never a sewer at all. Or if it was a sewer, it was not a sewer within the words of the Act of Parliament and was never vested in the local board. And they cannot be called upon to do what they've been called upon to do by these proceedings. And then he goes on to consider and answer the question over the page. In my judgment, so much of the sewer, so to call it, as was put without any sanction or licence on another person's land, and which that other person had a right at any moment to stop, cannot be part of a sewer within the meaning of the Act of Parliament. The sewers take things away, but one needs, and the other judges agreed. The next case in this bundle is at tab 36, page 232, Clark and Epsom. This was a case about a claim for the insufficiency of the infrastructure. The argument was it's not justiciable in the court, but was a matter for the Ministry of Health. A sewer had been built, but the disposal works to which they took the sewage became inadequate. The question was whether the local authority was responsible, and one sees what was held in the head note, but in fact the head note is not accurate because there was a finding that the relevant pipes were indeed sewers, and one sees first of all at page 238 at the bottom of the page over to 239 there's a reference to me. It was argued that the sewer had ceased to be a sewer because the outfall was unlawful under primary legislation, namely the Thames Conservancy Acts, because they polluted. And over the page, on page 294, Mr. Justice Morn decides that provided a sewer serves the function of carrying off sewage, it is still a sewer, even if its discharge starts to cause pollution unlawfully. This again obviously becomes relevant when one's considering the provisos. If there's a breach of the proviso, the sewer doesn't cease to be a sewer. Assuming the analogy can be made with previous legislation. Then we can put this authority away. We can turn to Blackdown Properties, which is in volume 2.2. That's tab 42. Page 406. This was a case where a sewer had been privately built. It was stopped up, but the pipe remained, and the local authority declared under the 1936 Act that the pipe should be vested in them. One goes to page 414, one sees what is in essence the conclusion that once the sewer, it remained a sewer, notwithstanding that it ceased at a particular point to function. It remains a sewer, notwithstanding the actual use has ceased. Because nobody is suggesting in the present case of intermittent sewers, or sewers through which there are intermittent sewers, that the use has ceased. But the point which we respectively derive from this line of cases is that it matters not whether the discharges are intermittent. It actually matters not, in principle, whether or not the sewer has stopped discharging. One still needs to consider the section 116 procedure, though of course if a sewer has ceased to have any function, it might not be necessary to provide a...
Well, there's nobody who's being deprived of use of it.
Exactly, exactly. But in this particular case, nobody can realistically suggest, I would respectfully submit, in relation to Mr. Morgan's point, that the sewers aren't used by those who have a right to connect and use the sewers upstream of the combined sewage outfall or emergency outfall, because they benefit from the discharges during heavy rain, for instance, and indeed, if it wasn't there, I think it's agreed by Mr. Morgan in his skeleton argument that effectively in heavy rain, if the emergency outfall, CSO, was not there, the sewer would back up and would surcharge back into the property of the person who has the right to connect and use the sewer under section 106.
It wouldn't back up into everybody's, but it would back up into those who are at the lowest level.
It depends, and it depends on the rainfall. It depends on the infrastructure.
So your submission is looking at the wording of section 116(3), but if you have one of these combined outfalls, even if it's only used once a year, when it is used, everybody whose sewage ends up going through the storm outfall is a person lawfully using a sewer for a purpose. And if you shut off that storm outfall, you're depriving all those people of the use of it.
Yes, and then one needs.
And therefore, you need to provide something that's equally effective.
Yes, and that's a question for the director.
In case of dispute.
We say that's how it works, given the nature of a sewer. Something doesn't cease to be a sewer just because it's not a sewer. It's not a sewer simply when it's discharging. It's a sewer because it performs the function, can perform the function within the infrastructure, and indeed doesn't cease to be a sewer even if, at the time the question comes to be considered, it's not actually performing the function.
So it's a bit like a fire extinguisher. A fire extinguisher is still a fire extinguisher, even if in fact you never have to use it to put out a fire.
Quite so. Then this case, nobody suggesting that the outfalls aren't in use. Indeed, the whole claim is predicated on the basis that we're facing a potential common law action that we're continuing to use our sewers.
Is there evidence as to how often in a year these outfalls are in fact used?
No. What we haven't done is condescend to analyse all the outfalls into the canal for the purposes of this litigation. You'll also have seen there were originally in the litigation some 127 outfalls being considered. Not all of them would have been within this category, but a significant number of them would have been. Some are more important than others, but it would be a significant task which we're seeking to avoid, to go into that level of detail.
Can you remind me what this category is? What is the category of outfalls which the 2018 proceedings embraces?
It relates to 4 sorts of outfall, which I was going to come to in the evidence, yes. But they are in essence these, since they are combined sewage outfalls, and I'll come to the evidence about those in a moment. They are emergency outfalls, emergency overflows. Yeah. Then there are storm tank overflows, and there are wastewater treatment, or outfalls from wastewater treatment works.
Are they all intermittent, or is the last category?
Well, the last categories you'll see that we're concerned with, they're not all going to be intermittent, but you'll see in the evidence the particular concern it relates to overflows. Perhaps the sensible thing is to take the court now to the evidence, which I was going to take the court to in any event before coming to section 117. The evidence is summarised by the judge, first of all, fairly briefly, at paragraphs 45 to 47 of his judgment, tab 12. Page 184, but it's very much a summary, as we'll see. We summarise the evidence in a little more detail at tab 4 on page 50 in paragraphs 6 to 9. Again, that's very much a summary, but the basis for this summary is found in the supplemental bundle in the evidence of Mr. Hazlitt at tab 5. It starts at page 101. The nature of the infrastructure is described from paragraph 8 and following at page 104. Of course, there was the suggestion that discharges which we're concerned about are voluntary or involuntary. We say it matters not for the purposes of the way we put the case, but I'll take your ladyship now we've got this open to the relevant paragraphs. For present purposes, I draw attention first of all to paragraph 15 on page 105, where Mr. Hazlitt starts to deal with combined sewer overflows, which he describes at paragraph 16. So they will be, by their nature, intermittent, but how often they are used will depend upon their precise location. At paragraph 17, in essence, he explains how they work. So when the combined sewage system becomes overloaded, storm sewage will escape at the lowest point where there is insufficient capacity. So if one's looking at whether it's voluntary or involuntary, the fact is it's the rain and the overloading that results in the discharge, not anything that we actively do during the rainfall. And then, for the court's note, in paragraph 22 and following, 22 to 24, Mr. Hazlitt deals with what will be required to deal with unsatisfactory intermittent discharges, generally from CSOs, storm tank overflows, and emergency outfalls. And one sees at paragraph 24 what one can do theoretically. Then he undertakes a similar exercise from page 108 and following in relation to storm tank overflows. He describes them in paragraph 25. Paragraph 28, he describes how they operate. He explains that the tank size is not finite, and then when there's excess capacity, there's a discharge. Again, if one is considering voluntary or involuntary, this is the evidence. This explains Mr. Justice Fancourt's use of the word, not in any technical sense, because he used it when he was summarising the evidence. And then paragraphs 30 to 31, he deals with what would be required to deal with an unsatisfactory storm tank overflow. Over the page, on page 110, he deals with emergency outfalls. In paragraph 32 and following, paragraph 33, again, he deals with the question of when they might occur. Well, he refers to mechanical failure. Well, sometimes mechanical failure might be due to negligence, in which case we admit there might be a claim against us. It could, in other instances, be simply due to insufficient machinery to deal with capacity, in which case we would say we're on the other side of the line, but we needn't go into the facts. Then again, he deals at paragraphs 34 to 36 with what's required to deal with an unsatisfactory emergency overflow, and then page 111, paragraph 37 and following, he deals with wastewater treatment works. So that's the evidence. I'm afraid, answering the question of my Lord Justice Nugee, the evidence is generic, but I hope, my lady, we've given the court sufficient material to understand the nature of the infrastructure with which we're dealing. So that's taken me a little out, of course, but it was a useful point with which to deal with it, because now we can come back to section 117, which, of course, is the proviso, which it is said is breached, or the terms of which is breached by the sort of outfalls at which we've been looking. That, my lady, back to the authorities bundle 1 at page 229. Section 117, one sees on page 229, is an interpretation provision. Over the page, one sees the proviso with which we're dealing here at subsection 5. It's framed, as is common ground, as a proviso rather than as a positive duty, and it has two links, A and B, and B with which we're concerned, one can see that it doesn't qualify sections 2 or 18 or 94, but it does qualify section 106, the right to connect, and section 116, the powers to, the conditional powers to stop up sewers. Perhaps I can just deal now, though we'll expand upon it later, with the issue of what this proviso is doing, whether it's OTOs. Absent this proviso, it would be open to a sewerage undertaker faced with an allegation that his sewers were polluting, to say, it is absurd to suggest that I am in breach of my section 94 duty, because I am expressly required by section 106 to accept connections, and not just connections, to allow drainage through those connections into the sewage system to anybody who wishes to connect, and B, I am precluded from stopping up the system. Now, of course, there might be arguments about whether that absurdity could stand with section 94. However, this proviso puts it beyond doubt. It is not OTOs. Now, there are other things which we say survive, but that, we respectfully submit, is one important function. Because this proviso on its face is not a proviso which in terms is aimed at preserving causes of action. It is about the extent of authority. Now, of course, an absence of statutory authority may in some instances give rise to causes of action. But this proviso, the starting point, is that it's about statutory authority. We say it has an important function in its application in terms to sections 106 and 116. It also has functions that we'll see when we look at Dobson, where one is looking at the extent to which common law rights might survive. So that's really what we say.
One of the chief purposes of a statute setting up an undertaking and conferring statutory powers containing a provision like this is to avoid the Allen and Guilfoyle argument that because Parliament's authorised the construction of a refinery, it must have authorised the use of a refinery in such a way which is going to cause what would otherwise be a nuisance. In other words, defence of statutory authority.
My lord, it can be, but in this, it can be, but not necessarily. We have, of course, in this statute, the express provisions of subsection 6, which apply to section 116, through which the right to discharge, as Lord Sumption found, was implicit, not to create a nuisance, and that performs that function in terms, we say. A sewerage undertaker shall not so carry on its functions under sections 102 to 105, 112, 115, 116 above, as not to create a nuisance.
And you say, do you, therefore, that if you read the section 117 as a whole, that the existence of 6 and the reference to nuisance there means that it's more natural also to read 5, subsection 5, in the way that you suggest.
Well, quite so. I'm not saying that it doesn't have the effect that. Ought to be clear. I do say I accept that if there is a breach of the proviso in section 117, subsection 5, subsection B, such that a discharge is not authorised, there may be a claim. But in deciding whether or not there is a claim, one then asks the Marchich question.
It seems a very odd thing to do for the statute to, on the one hand, preserve the possibility of a common law claim, and then on the other hand, take it away, not expressly, but by the Marchich process of seeing if they're incompatible.
But as I've indicated to your Lordship, my submission is that on its face, subsection 5B
is doing something else.
It's doing something else. It does have the effect that there would be a lack of statutory authorisation, and then one needs to go on to consider what is the remedy for that lack of statutory authorisation. But subsection 6 is the one in terms which refers to nuisance, which on its face is about claims. So there might be a question as to what's the remedy if there is a nuisance. But one could see here that we have 2 provisos, the second of which is directed, we say, at the sort of the Allen and Gulf oil question.
I thought that on section 117.6 is a continuation of pre-1991 statutory provisions, and I thought some of the old cases drew a distinction between the creation of a nuisance and just operating a system which you've inherited.
Yeah, well, there's the yes, that is so, but
it doesn't say a sewage undertaker shall so carry out its functions that there will be no nuisance. It says so as not to create a nuisance, and I thought the cases had drawn some subtle distinctions as to whether you did create a nuisance.
Well, I respectfully submit that those distinctions might well not survive this Act, because, of course, this provision is far more limited in its application. It's not it applies only to a certain number of sections, as indeed section 117 subsection 5 is far more limited in its scope than the old provisos, which extended to the pipe laying powers. This, we respectfully submit, is more limited, and in both. And when looking at subsection 5B, to repeat the point, and I'll make the points more fully when I develop my submissions, we say, in terms, looking at it both literally and naturally, it's about statutory authorisation. And then one needs to consider in any given case, what is the consequence of that statutory authorisation? This section on its face does not go that far as to tell us. And I hope I've explained to the court what functions that has within the structure of the Act as a whole. It's a proviso which applies to sections 106 and 116, which on the face of it might be said to create a tension with section 95. Of course, there would be an argument absent the proviso, but the nature of provisos is that they put the matter beyond doubt. The extent to which it puts the matter beyond doubt is perhaps questionable, given that we're here arguing about it.
Can I put it this way? Your case is, it doesn't say under 117.5b and 6, and any such prejudicial affection or any such nuisance shall be actionable at the suit of any person thereby affected.
Yeah, in the courts. Of course, the absence of statutory authority I respectfully submit, of course, might lead to complaints that there's a breach, or because if the result is that the water quality of a canal or other water course is prejudicially affected, we'll submit, as seen from the skeleton argument, that by its nature is a failure effectually to deal with the contents of sewers. There is a breach of the Section 94 duty. So there are two express remedies under the legislation. Or there could be two express remedies under the legislation, depending on what the regulators decide. First, there's the Section 18 route, and if there's non-compliance, there's the possibility of an action. But there is also express provision under Section 95 for the Secretary of State to provide a remedy, as he did do the Marchich problem.
And you might also be exposed to criminal liability if you were in breach of your permits.
Oh, quite so. That'll be a separate question, and that will be essentially, as has been explained to the court, a matter for the statutory judgment of the Environment Agency as to how they take that forward, whether or not they accept undertakings or whether they prosecute. My lord, similar points can be made under section 186, which is at page 274. We're concerned with 186 subsection 3. Again, it's nothing in the relevant sewerage provisions shall authorise the sewerage undertaker injuriously to affect. It's concerned with injurious affection, which in some instances might be different from mere pollution, might go further than pollution. For instance, silt might not pollute, but it might cause injurious affection. But in essence, it comes down to the same point. It provides for an absence of authorisation. If the absence of authorisation is pollution, so it engages a breach of the Section 94 duty, then we say, as we hope to make good in our submissions later, there's the enforcement mechanism under Section 18, and possibly if the Secretary of State decides a remedy under Section 95. Of course, if the harm caused, if the injurious affection doesn't amount to a breach of the Section 95 duty, then the absence of authorisation may give rise to a common law claim. And it's a slightly wider proviso because it applies to the relevant sewerage provisions, the list of which has been provided to your ladyship. So that's what I have to say about the 1991 Act. Just before the short adjournment, I can just refer the court to what we say about the Water Resources Act and the environmental permitting regulations. We summarise the position slightly more fully than Mr. Hart did at our supplemental skeleton dealing with the submissions of the interveners. That appears, we needn't turn it up now, it appears in volume 2, tab 28, page 572, and the paragraphs are at paragraphs 5 to 6, and they're on pages 572 to 574. And we pick up, and it is potentially significant that if an enforcement undertaking is accepted by the Environment Agency instead of prosecution, there is, possibly potentially in addition to, there's provision for payment to people affected by pollution. So there's a potential remedy for people even under that route, which we say dovetails with the Water Industry Act. The individual citizens aren't outside that regime. I don't propose to read that, and I'll pick up on my main submissions after the short adjournment, if I may.
Do you accept that individual citizens could bring private prosecutions for criminal offences?
In principle, they can, but I'm not sure we have any examples of it having been done, because I suspect in practice, of course, it's going to be highly technical.
Quite
needs
expensive.
a lot of evidence.
Mr. Hart?
A man called Hart, not me, prosecuted the Anglian Water Company privately in respect of fish kill. So it does happen occasionally.
Yeah.
Thank you.
Quite well. I'm happy to be corrected, but of course there we had dead fish, where there's very often it will be a matter of highly technical evidence as to the extent to which there has been a breach of permit.
How are you proceeding, Mr. Karras? You're doing
Slowly, but I think I hope I'll be able to speed up now. It has been my fault in being rather slower than I should have been in
No, we've asked you lots of questions. Thank you very much. 2 o'clock.